The legislation was fast-tracked through the UK Parliament, and one of the reasons for this was the UK government's response to Russia's invasion of Ukraine. It has been designed so it will be easier to identify and trace proceeds of crime. It addresses the concerns of dirty money laundered via property and other assets, and of course, secretive ownership of assets. There are three key changes which I will go through now. One, lowering the ability threshold for imposition of civil monetary penalties for breaching financial sanctions. Two, expanding the remit of the existing unexplained wealth order tool. And three, creating an identity register for beneficial owners of overseas entities holding UK property. A failure to comply with sanctions legislation can constitute a criminal offence subject to fines and imprisonment. The Office of Financial Sanctions Implementation, or OFSI, is the UK sanctions enforcer. OFSI has the power to impose civil penalties of up to £1 million or 50% of the value of the breach, whichever is higher. To date, this has been OFSI's favoured method of enforcement. Under previous sanctions legislation, OFSI could not impose a monetary penalty on a corporate or individual unless OFSI was satisfied on the balance of probabilities that the person knew or had reasonable cause to suspect that their conduct breached a financial sanction or that they failed to comply with their obligations under the regime. But under the Act, the knowledge requirement has been replaced by strict liability. And what that means is a person's intent or knowledge surrounding the breach is irrelevant to the question of whether OFSI has the power to impose a civil monetary penalty. The new test is more closely aligned to the US model, which means you're likely to see businesses being fined because OFSI no longer has to show knowledge. Knowledge is still important in criminal cases and can amount to a defence, in particular if you do not know or couldn't have suspected any sanctioned breach. However, it will not be enough if a civil fine is imposed on you. In my view, this means you will see an increased activity of civil enforcement towards companies and individuals. It seems to me there is now likely to be an increased risk of reputational damage for businesses in breach of financial sanctions. I say this because OFSI already has the power to publish details of any monetary penalties that have been imposed. In fact, under the new Act, OFSI can actually publicly name and shame entities or individuals it believes has breached sanctions, even where a fine has not been imposed. Now, at a time of heightened sensitivity around corporate affiliations with Russia, this would obviously be welcomed publicity. It is important to note unexplained wealth orders, or UWOs, are an investigative tool introduced in the UK under the Criminal Finances Act in 2017. An UWO requires a respondent to explain the legitimacy of the source of funds they used to acquire property held in the UK or overseas, where there are reasonable grounds to suspect the person's known lawful income would be insufficient to buy the relevant property, and where that person is either 1, a politically exposed person or PEP, 2, connected with a PEP, or 3, there is suspicion that they are involved in serious crime. If the respondent cannot evidence legitimate funds, the property can be frozen or seized. The new Act introduces a number of changes to make it easier for UK law enforcement to obtain UWOs. It limits the costs that enforcement authorities are required to pay as a result of a failed UWO application. This is, of course, likely to increase the use of UWOs by law enforcement, who will not be penalised where their application has failed. Law enforcement has been given more time to investigate material received in response to an unexplained wealth order before discharging any interim property freezing order over the assets in question. So I believe it's from 60 days to 186 days. For any property that is held via offshore or trust structures, UWOs can be issued to any of a corporate respondent's responsible officers, including its directors, board members, managers, and trustees. For businesses, particularly banks or firms holding assets of a respondent subject to a UWO, there may well be a considerable amount of negative reputational impact for simply being associated with the individuals concerned. In addition to this, it could even provoke further scrutiny by authorities of the firm's current due diligence practices, financial crime systems, and controls. Respondents to a UWO tend to be wealthy individuals or corporates. As properties are not always purchased in cash, it is likely they will be subject to some sort of mortgage or secured loan. Part of the income requirement test used to assess whether legitimate sources of the individual's income would have been sufficient to enable them to acquire the asset in question requires scrutinizing the mortgagor, which may, as a result, inadvertently push the bank into the limelight. The authorities or regulators are likely to ask why its own due diligence procedures did not pick up on the allegedly illicit funds. For a bank or firm, having a customer that is a respondent of a UWO does not necessarily mean that there has been a failure within the firm, either at customer onboarding or during the course of the business relationship. Because of the new act, a firm should now actively review its association with the respondent once it becomes aware of the UWO. It also needs to be aware of any legal restrictions on moving assets that arise from any court order. The Act has introduced a new register requiring overseas entities owning property in the UK to register with Companies House and identify its beneficial owners. Penalties for non-compliance include criminal liability, which, depending on the offence, can be punishable by up to 5 years imprisonment for the most serious breaches, and fines. The UK government has said that the civil sanctions also include financial penalties and restrictions. Anyone with investment interests in assets subject to restrictions imposed as a result of non-compliance with registration requirements may be impacted by restrictions imposed as a result of non-compliance. Importantly, the Act will apply retrospectively, and this means you will see heightened scrutiny on due diligence undertaken on transactions that involve the purchase of UK property, in particular regarding beneficial owners, persons with significant control, and connected individuals.